Part 4. Liability of the consignor. Article 22. General Rule: the consignor shall be liable for loss sustained by the multimodal transport operator if such loss is caused by the fault or neglect of the consignor or his servants or agents when such servants or agents are acting within the scope of their employment. Any servant or agent of the consignor shall be liable for such loss if the loss is caused by fault or neglect on his part. Article 23. Special rules on dangerous goods. 1. The consignor shall mark or label in a suitable manner dangerous goods as dangerous. 2. Where the consignor hands over dangerous goods to the multimodal transport operator or any person acting on his behalf, the consignor shall inform him of the dangerous character of the goods and, if necessary, the precautions to be taken. If the consignor fails to do so and the multimodal transport operator does not otherwise have knowledge of their dangerous character, A. The consignor shall be liable to the multimodal transport operator for all loss resulting from the shipment of such goods, and B. The goods may at any time be unloaded, destroyed or rendered innocuous, as the circumstances may require, without payment or compensation. 3. The provisions of paragraph 2 of this article may not be invoked by any person if during the multimodal transport he has taken the goods in his charge with knowledge of their dangerous character. 4. If, in cases where the provisions of paragraph 2b of this article do not apply or may not be invoked, dangerous goods become an actual danger to life or property, they may be unloaded, destroyed or rendered innocuous, as the circumstances may require, without payment of compensation except where there is an obligation to contribute in general average or where the multimodal transport operator is liable in accordance with the provisions of Article 16. Part 5. Claims and Actions. Article 24. Notice of loss, damage or delay. 1. Unless notice of loss or damage, specifying the general nature of such loss or damage, is given in writing by the consignee to the multimodal transport operator not later than the working day after the day when the goods were handed over to the consignee. Such handing over is prima facie evidence of the delivery by the multimodal transport operator of the goods as described in the multimodal transport document. 2. Where the loss or damage is not apparent, the provisions of paragraph 1 of this article apply correspondingly if notice in writing is not given within 6 consecutive days after the day when the goods were handed over to the consignee. 3. If the state of the goods at the time they were handed over to the consignee has been the subject of a joint survey or inspection by the parties or their authorized representatives at the place of delivery, notice in writing need not be given of loss or damage ascertained during such survey or inspection. 4. In the case of any actual or apprehended loss or damage, the multimodal transport operator and the consignee shall give all reasonable facilities to each other for inspecting and tallying the goods. 5. No compensation shall be payable for loss resulting from delay in delivery unless notice has been given in writing to the multimodal transport operator within 60 consecutive days after the day when the goods were delivered by handing over to the consignee or when the consignee has been notified that the goods have been delivered in accordance with paragraph 2b or of Article 14. 6. unless notice of loss or damage, specifying the general nature of the loss or damage, is given in writing by the multinational transport operator to the consignor not later than 90 consecutive days after the occurrence of such loss or damage or after the delivery of the goods in accordance with paragraph 2b of Article 14. Whichever is later, the failure to give such notice is prima facie evidence that the multimodal transport operator has sustained no loss or damage due to the fault or neglect of the consignor, his servants or agents. 7. If any of the notice periods provided for in paragraphs 2, 5 and 6 of this article terminates on a day which is not a working day at the place of delivery, such period shall be extended until the next working day. 8. For the purpose of this article, notice given to a person acting on the multimodal transport operator's behalf, including any person of whose services he makes use at the place of delivery, or to a person acting on the consignor's behalf, shall be deemed to have been given to the multimodal transport operator, or to the consignor, respectively. Article 25. Limitation of actions. 1. Any action relating to international multimodal transport under this convention shall be time-barred if judicial or arbitral proceedings have not been instituted within a period of 2 years. However, if notification in writing, stating the nature and main particulars of the claim, has not been given within 6 months after the day when the goods were delivered, or where the goods have not been delivered after the day on which they should have been delivered, the action shall be time-barred at the expiry of this period. 2. The limitation period commences on the day after the day on which the multimodal transport operator has delivered the goods or part thereof, or, where the goods have not been delivered, on the day after the last day on which the goods should have been delivered. 3. The person against whom a claim is made may at any time during the running of the limitation period extend that period by a declaration in writing to the claimant. This period may be further extended by another declaration or declarations. 4. Provided that the provisions of another applicable international convention are not to the contrary, a recourse action for indemnity by a person held liable under this convention may be instituted even after the expiration of the limitation period provided for in the preceding paragraphs if instituted within the time allowed by the law of the state where proceedings are instituted. However, the time allowed shall not be less than 90 days commencing from the day when the person instituting such action for indemnity has settled the claim or has been served with process in the action against himself. Article 26. Jurisdiction. 1. In judicial proceedings relating to international multimodal transport under this convention, the plaintiff, at his option, may institute an action in a court which, according to the law of the state where the court is situated, is competent and within the jurisdiction of which is situated one of the following places: a. The principal place of business, or, in the absence thereof, the habitual residence of the defendant, or b. the place where the multimodal transport contract was made, provided that the defendant has their place of business, branch or agency through which the contract was made, or c. the place of taking the goods in charge for international multimodal transport or the place of delivery, or d. any other place designated for that purpose in the multimodal transport contract and evidenced in the multimodal transport document. 2. No judicial proceedings relating to international multimodal transport under this convention may be instituted in a place not specified in paragraph 1 of this article. The provisions of this article do not constitute an obstacle to the jurisdiction of the contracting states for provisional or protective measures. 3. Notwithstanding the preceding provisions of this article, an agreement made by the parties after a claim has arisen, which designates the place where the plaintiff may institute an action, shall be effective. 4. A. Where an action has been instituted in accordance with the provisions of this article or where judgment in such an action has been delivered, no new action shall be instituted between the same parties on the same grounds unless the judgment in the first action is not enforceable in the country in which the new proceedings are instituted. B. For the purposes of this article, neither the institution of measures to obtain enforcement of a judgment nor the removal of an action to a different court within the same country shall be considered as the starting of a new action. Article 27. Arbitration 1. Subject to the provisions of this article, parties may provide by agreement evidenced in writing that any dispute that may arise relating to international multimodal transport under this convention shall be referred to arbitration. 2. The arbitration proceedings shall, at the option of the claimant, be instituted at one of the following places. A place in a state within territory is situated the principal place of business of the defendant, or, in the absence thereof, the habitual residence of the defendant, or the place where the multimodal transport contract was made, provided that the defendant has their place of business, branch or agency through which the contract was made, or the place or taking the goods in charge for international multimodal transport or the place of delivery, or b. any other place designated for that purpose in the arbitration clause or agreement. 3. The arbitrator or arbitration tribunal shall apply the provisions of this convention. 4. The arbitrator or arbitration tribunal shall apply the provisions of this convention. 5. Nothing in this article shall affect the validity of an agreement on arbitration made by the parties after the claim relating to the international multimodal transport has arisen.